So let's talk about this with Lisa Longstaff. She's a spokesperson for War Against Rape, and Joseph Kotrie-Monson is with us as well, director of Mary Monson Solicitors in London, Birmingham, and Manchester. He specialises in sexual offence cases, women against rape. I beg your pardon. Is Lisa Longstaff. Lisa, a very good morning to you.
Good morning.
What was your first impressions when you heard that the jury, after 2 hours, had handed down a verdict of not guilty?
Well, women are appalled at the verdict. We had a lot of calls and contact with women yesterday who are very worried that this is setting a dangerous precedent for the future because of the sexual history evidence that was allowed.
Right. But it was admissible, this evidence, because the judge took the view that in order to get a fair trial, her past history and sexual behaviour was relevant. Yeah,
that's right. There is legislation against women's sexual history being brought up, which we actually campaigned for throughout the 90s. But unfortunately, when the government introduced it, they brought in so many exceptions that unscrupulous and devious barristers and sexist judges can allow all kinds of information about women which we consider really irrelevant and very prejudicial and damaging.
Mm.
Can I just explain why? The principle is that we don't believe that sexual history with other partners is relevant to whether she consented on that time with that person who is on trial.
But
that's the principle.
I understand the principle, but do you salute the fact that a man has been found not guilty of something that he's not guilty of?
No, I'm afraid I don't. I think that this whole incident has smacked of bribery and corruption. There was a lot of evidence brought at the trial by the prosecution that suggested that information may have been fed to witnesses, that there were inducements given, and I think I'm afraid, in the pattern of wealthy and powerful men being able to throw their weight around and have sex with women in very unsavoury circumstances, whether or not they consented. And this is happening on both sides of the Atlantic. You'll have seen the Stanford case. You'll have seen, what's happening with Trump, as you mentioned earlier. I think it's a pattern, and I think it has to be stopped. Otherwise, women are just fair game and treated like a piece of meat.
Well, I'll come back to you, and I'll talk to you about how men should fare in these particular situations as well. But let me just bring in Joseph Kotrie-Monson to talk about what he's just heard there. Your impressions when this jury handed down the not guilty verdict first, please, Joseph.
Well, Andrew, if I might start by saying that I have I respect deeply people like Lisa Longstaff. It's the work that they do that's led to the changes of the law that makes it very difficult for this type of evidence to be admitted. Even if I have to reluctantly point out some basic inaccuracy in what's been said about this celebrity case, and I have to say, once we're blurring the lines with Trump and other cases, we're not actually talking about the points of this case, and that actually just serves as a distraction. Quite an emotional one. It's important to look at this logically. It might be useful if I can point out what the situation is in a bit more detail than we've heard, although it's been a good start as far as English law is concerned. There are, we've heard, it's right, 2 barriers to having any irrelevant evidence about previous sexual conduct heard in court. And the first is that evidence has to be relevant, and relevant doesn't just mean interesting. It means it can't be just prejudicial. It has to be more prejudicial than probative. And that means that a judge will stop you the second that you're talking about trying to raise something or ask a question that does nothing more than mudslinging. However, and it's right to point out that because there is a real fear of victims or, rightly survivors of rape not coming forward because of fear of being questioned about their sexual history, which is, of course, generally speaking, irrelevant per se, then there is this further barrier which the law essentially forbids it. And that does present something of a problem because, as most people would guess, if there is evidence of another person, from another person, or in this case, 2 other people, of something that the alleged victim supposed to have done, and they say done, that was so similar, not to what the complainant, the alleged victim, says, but actually supports what the alleged rapist says, often when there's no other corroboration, because it's so similar, then there is a palpable risk there, isn't there, that an innocent person will be convicted of rape.
Let's take a view from Lisa Longstaff, from Women Against Rape. I'm sure you'd like to say something, Lisa, about that.
Yeah, I mean, I obviously was following the case carefully, and one of our members was in court at the appeal. We didn't think it was strikingly similar. We think the judge made the wrong decision, and we think that this sets a really dangerous precedent for future cases, because how she was behaving on other occasions with, when she was having consenting sex with men she knew, should not be able to prove that when she said she wasn't consenting because she was out of it and she didn't know what she was doing, that proved that somehow it wasn't rape. To me, it's just not logical.
Joseph, come back on that, please.
If I may, I don't want to get bogged down in the whys and wherefores or the innocence or guilt of Ched Evans. The reality is, the law says he's an innocent man. We should be very careful about saying he's guilty. If he's got criminal lawyers, he's got libel lawyers too, and there's no doubt that he should be considered, in public as an innocent person, whether you agree with it or not. But the reality is here, it wasn't just evidence from one person, it was two. And I think there's a fundamental danger here of just labelling judges sexist, labelling barristers sexist. I'm offended by that. I'm a feminist, I'm a progressive, I came in law to help people, I came in law to change the establishment, not to be part of it. And I say that most reluctantly and most gently because I know the subject matter and I know where this lady is coming from. But aren't we in a danger of just coming to a situation where that irrespective of however good, I just sometimes wonder, how good would this evidence have to be? How obvious would it have to be that it proves somebody's guilt before certain campaigners would turn around and say, well, actually, we'll allow it? We're in danger, for the best of motives, which is protecting victims and making them feel that they can come forward, making a mockery of what the process of court is supposed to be.
Okay.
And that's figuring out who's innocent, figuring out who's guilty, fairly.
Joseph, I wonder if I could just ask for a wrap-up here from Lisa Longstaff. 30 seconds here. I want you to just address what I know my listeners are going to be thinking about here as well. What about men who are falsely accused of rape in the first place?
Okay, well, this always comes up like a bad penny because there is this myth that...
Well, there's an awful lot of men who are accused of rape and have their lives ruined and their families ruined and their reputations ruined as well.
Every time, but, I have to just go back to the point that there has been traditionally... It's been really hard to get a conviction for rape because the evidence hasn't been gathered properly, the case has not been properly judged, it hasn't been properly heard in court, and the jury are misled by irrelevant and prejudicial details.
Yeah. Okay, Lisa, I'm so sorry. For time reasons, we do have to wrap it up there. It's over to you. It's 03456060973. We'll talk about Ched Evans and the implications of this. It's 8:17. It's a Saturday morning here on LBC.